As you all are getting settled in, could you give me an update about what's been happening since yesterday?
Yes.
Body cams and Mr. Duke in particular,
Yeah,
if
so
you know.
we received 10 additional body cams from DPD yesterday. And we turned those over to the defense. Got those uploaded as quickly as I could. Got them up to the defense. With regard to Mr. Duke, he called
There he
me.
is.
I'm sorry.
I literally just went to find something. I'm sorry.
You're good, that's all right. I just wanted an update if you have one.
Mr. Rosales intends to focus different rights and not as well.
Fascinating. So what do you intend to do with that?
I'm sorry, Judge.
If he's going to invoke his Fifth Amendment rights not to testify, what do you intend to do?
With regard to,
Are you going to offer him immunity or anything?
no, sir.
And Mr. Duke did ask if you would offer, you did ask the state if you would offer immunity, didn't you?
I did, Judge. I received the immunity agreement last night, which was use immunity only for the grand jury testimony. It's in writing, it's spelled out pretty specifically in the motion to compel testimony. So to my understanding, and I confirmed with the state, is that Mr. Rosales does not have, or I guess not on the record, he doesn't have immunity now, and so, and the state has indicated that they do not intend to extend immunity, which is went into my advice to Mr. Rosales to invoke his Fifth Amendment rights.
Judge, I have a request related to that. I'm going to make an offer today to admit the probation statement under Rule 8035, recollection recorded. And I would ask that because I've got to prove faded memory, although the rule says it doesn't matter if the declarant is available or not. I would ask that counsel show Mr. Rosales the statement and simply ask him if he remembers making it, so that I can establish that he has no memory of it, and then move to admit the document through that rule.
How long are these videos?
I can tell you, Judge.
I still have 2 to watch. Some are longer than others. Of the 10 videos, I found 2 that have things that I would like to know. To be frank with the court, one of them is somebody speaking to Mr. Rosales and him again lying about there not being a gun. He does it once on another videotape, but it's a different time he asked and a different officer asking this time.
Out there at the scenes? Yeah. Okay.
So, one is 10 minutes and 58 seconds, one is 15 minutes and 2 seconds, one is 9 minutes and 34 seconds, one is 2 minutes and 6 seconds, one is 15 minutes and 16 seconds, one is 45 minutes and 40 seconds. That is one where an officer is transporting Mr. Rosales to headquarters. There's no conversation between the officer and Mr. Rosales. One is 15 minutes and 4 seconds. One is 2 minutes and 52 seconds. One is 14 minutes and 36 seconds. And the last one is 17 minutes and 20 seconds.
Okay.
And Your Honor, we're very likely going to ask for all this to be put on the record again, just with the amount of video that
Yeah,
it
we
is.
will. I'll give you a chance to do it. What do you want to do with all of that, Ms. Madsen? I mean, I guess what I'm asking is, I feel like you need to see that. And I feel like you have not, and I also feel like it's going to take some time for you to see that. But I'm saying that as if you want to see it. I don't know whether you want to see this stuff or not.
Of course.
Okay. So, are you going to ask me for, how much time do you want to watch all this stuff? And I'll say this too. If it puts your whole case on hold, I don't have any problem with that. If it doesn't put your whole case on hold and there's other stuff you can put on, and I don't know your case like you do, then okay, we can do some of that today. I was intending on giving you all Monday anyway because of the court's prior commitments regarding my specialty courts. So with that in mind, what do you have? Do you have any idea what you'd like to do? You want to stop everything right now and come back Tuesday? Do you want to put some testimony on and then stop everything? And I think I probably should let you go talk to your team about that.
May I have a moment?
Of course.
Alan?
Yes.
Way to go, Mr. Duke. Came in, saved the day. I guess. You want to go back there with him, Mr. Mitchell?
Sure.
Try to see. Hey guys.
You know, like
So what are we doing? What are we
the,
doing?
like the NBA team where the opposing player will just stand in the huddle until they look at
He
him.
even put his arm around.
Yeah.
Mm.
It takes a second for them to realize who that is.
And Mr. Lewis, if I could, before you do that, I did mean to ask you this, but I will need to know at some point. These 10 officers, or whatever, they're from 10 separate officers, right?
That's correct.
Okay, and did any of those officers make notes about what they did or saw, and those notes have been turned over, but it's just not these body cams that have been turned over? And if you
Yes.
don't know, can you check?
There was, I believe, two did supplements where it states what they did. The other ones, there were no notes at all.
Okay, can you make a note of that? And then, that's the first one. The second is there a list of those officers somewhere? Like, all these officers were on scene or responded or did this. And is there any indication in the file that they had body cameras?
Okay.
So I need to know that information. Please. Why don't y'all two come on up here real quick? Super secret, off the record. Let's do this real quick. Let's go on the record. This is, well, we need Mr. Hess, don't we? This is the state of Texas versus Mr. Christopher Hess. The record should reflect we're outside the presence of the jurors. The record should reflect that Ms. Madsen has moved to call Mr. Rosales, who is a co-defendant. I appointed Mr. Cliff Duke to represent Mr. Rosales, who is present in court today. State's present as well. Ms. Wood, do you have Mr. Duke's bar number?
I may have it.
All right. Sheriff, could you bring out Mr. Rosales, please? I appreciate you being available, by the way. Such short notice. That should be part of the record this week. And while we're waiting on him, could somebody give me, please, Mr. Rosales' grand jury testimony? I don't know what exhibit number that is, but I've got a copy right here. Thank you. How we doing?
He's good.
Okay. Good morning, Mr. Rosales. Hi. Can you talk louder so that I can hear you, please? All right. Can you please, first of all, tell me your name? It's Rosales, is that correct? Please raise your right hand to the best of your ability. You swear the testimony that you're about to give will be the truth?
Yes, sir.
Okay, very good. Mr. Duke, I'll let you take it from here.
Mr. Rosales, you and I had a chance to meet this morning regarding you potentially being called as a witness in the case that's pending before this court right now. Is that right?
Yes, sir.
You understand that the attorneys that have been appointed to represent the defendant have requested that you be called as a witness, is that right? And you and I had a chance to speak, and I explained to you that while you were granted immunity for your testimony prior in front of the grand jury, the agreement for that immunity does not extend to any testimony that you may give in court today. Is that right?
Yes, sir.
And so I explained to you that any statements that you make here in court could be used against you in future proceedings, if any. Is that right? And I also advise you, the state of Texas has indicated to me that they do not intend to extend any further immunity for any further testimony from you. Is that right? And based on all of those conversations, you have then indicated to me you intend to invoke your Fifth Amendment rights against self-incrimination and not testify in these proceedings today. Is that right?
What was the answer?
Yes.
Okay. All right. Thank you very much. That's all.
Oh, Your Honor, may I?
Before he excuses, before you take him away, yes, sir.
I would argue that the immunity order itself is broad enough in scope to cover Mr. Rosales' Fifth Amendment rights today, in that it states any adjudicatory proceeding, that includes this one, and it's written so broadly as to include anything that happens on the 18th of January 2017, which would be the subject of his testimony.
And you're basing that on the defendant's exhibit number 40?
Yes, sir.
I've got it. Thank you,
The order
Mr.
itself.
Bell.
It's written the way it's written, and I believe it covers him just fine today.
You have any reply to that, Mr. Gladden or Mr. Lewis?
Yes, Judge. The immunity agreement, I'll just read from it. Witness Virgilio Rosales be granted use immunity concerning any testimony he gives under oath before the grand jury related to this ongoing investigation. It's limited to his testimony before the grand jury. Anything he says on the stand today is not before the grand jury. It's before a petit jury in the case against Christopher Hess. That's a completely different proceeding.
However, the order is not worded that way, and the order controls.
It also says, and that any evidence and testimony adduced through this witness or information derived therefrom may not be used against the witness in any adjudicatory proceeding except a prosecution for perjury or aggravated perjury. And I think that's what you're talking about. Based on false testimony, you know, and then it completes there.
And Judge, that's language concerning use and derivative use immunity, right? That is the scope of immunity consistent with the Fifth Amendment privilege against giving testimony in a given proceeding. So what that tells Mr. Rosales is that when he testifies in front of the grand jury, what he says there can't be used against him. And any evidence derived from that can't be used. So in other words, his testimony can't be used as a lead to get other evidence against him. It has nothing to do with him getting up on the stand under oath and giving new testimony, which is not evidence derived from his grand jury testimony, but it's evidence derived from questions by counsel for Mr. Hess and counsel for the state.
All right.
We will be asking him questions about his grand jury testimony, and as it dovetails into the rest of the event, which is covered by the order the rest of that day.
All right. I agree with Mr. Gladden regarding the scope of the order. And what I'm reviewing now is the testimony of Mr. Rosales in the grand jury that is an exhibit, although I don't know which one. And while I'm doing that, Mr. Lewis, do you intend on offering him immunity today to testify?
No.
Your Honor, so the record is clear, that would mean that the state offered him immunity to testify on their behalf to the grand jury on these same matters, but they are intentionally refusing to do so, knowing it will prevent the jury hearing his testimony, and it means we cannot call him as a witness.
And that violates the 14th Amendment.
Okay. All right. You can go back. Thank you, Mr. Rosales.
I have one more thing before he goes back.
Oh, okay. Go ahead.
I'd like to offer Defense Exhibit 42 for record purposes, the probation statement made by Mr. Rosales.
Any objections for record purposes?
Not for record purposes.
And I would ask that.
Is there any particular part of that you want me to read?
Yes, sir.
I've not seen that.
11317 court appearance and below is what I'm
Okay.
going to be asking about.
Alan, you have a copy for us?
I have one you can borrow for now. Here you go.
Okay, and what's the purpose of the offer? Sorry.
The
I've read
purpose
it.
of the offer is that under Rule 8035, the probation statement is admissible at the exception to the hearsay rule as past recollection recorded. The rule does not require witness unavailability, but the first part of the rule requires that a lack of memory be demonstrated. I would ask that counsel for Mr. Rosales show him the document and ask him privately if he remembers making the statement. And then maybe give you the answer to that in camera, so that I can hopefully operate under Rule 8035.
All right. Your request is denied. Is there anything else for Mr. Rosales? Mr. Duke?
Nothing from council, Judge.
Thank you very much. That's all. You may. It's possible that you might get a phone call later. I don't know.
Sir.
Appreciate that.
I've got another copy.
Here you go. I don't need this. Okay.
Your Honor, at this time, we'd like to take up a couple of other matters on the record.
Well, hold on. Mr. Duke's still here.
May we approach this, Judge?
Sure. What's happening?
Is this all?
No.
Okay. You all stand back.
I made a request of counsel for Mr. Rosales to review what's been admitted as Defendant's Exhibit 42 for record purposes, the probation statement, to make a determination about an exception to the hearsay rule, whether he believes it fits or not, and to look at whatever he needs to look at to form an opinion about that and inform me of that. Hopefully, that will clear all of this up and make that statement admissible on a different basis.
Judge, I think you've ruled on
Well-
possible hearsay.
Well, we're not done yet.
Can you tell us?
Well, hold on just a second. We are done with this on the record right now. With all due respect to Mr. Duke, if you're willing to make a proffer, then make a proffer. If you want me to make a ruling, I'll make a ruling. But asking Mr. Duke, if you want to take up the court's time now on the record, then let's get it out there, because to me, that document is hearsay. It's not a recorded recollection within the meaning of the statute. You're not able to prove that. So unless you have another hearsay exception, I need to hear what it is. Otherwise, Mr. Duke, you're dismissed.
Your Honor, we do. We would offer it as a statement against penal interest. I would note that the court referred to Mr. Rosales as a co-defendant in this case, and that at the time he was making that statement, he was talking about the criminal offense. He was talking about the offense that you have dubbed him a co-defendant of. And because of that, it's a statement against penal interest, and it is a hearsay. It is an exception to the hearsay rule.
And I have one more thing on that, and I'll be finished, and that is this. The evidence equation has changed as a result of Mr. Rosales taking the fifth and the state's refusal to grant immunity, and that's based on the following. He took the fifth on advice of counsel because there's a perception that he has criminal liability here for the event we want to talk about. The state has refused to grant immunity because the state thinks he might have criminal liability in the event we want to talk about, and they may want to prosecute him later for it.
I disagree with that. There's no evidence or proof of that. Both what you and what Ms. Madsen have said is making an inference and a supposition based on their refusal to grant immunity, and I cannot sponsor that. You all may be right, but I can't sanction that and say you are right.
And I have
So,
just
so
one more
with,
thing.
with that in mind, go ahead and finish your thought.
I would submit that based on this item of evidence and the character and context in which we've been talking about it, that it's now admissible as a declaration against penal interest, roughly enough to invoke the provision of Rule 102 to bring it in. These rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law to the end of ascertaining the truth and securing a just determination. That is somewhat of a catch-all, which would allow this item of evidence to come in if it's trustworthy enough, and it is.
All right. Your request is denied. Now, let's take up the body cam issue. Like yesterday, the court, and the record should reflect that the court was aware that certain body cams were not turned over. Ordered the parties to figure all that out. My understanding from Mr. Lewis and Ms. Madsen is there's approximately 10 body cams now, body cam videos of varying lengths from 2 minutes to 45 minutes that have been turned over. Ms. Madsen, you had requested to make a record. I think that's where you were going with this.
No, Your Honor, I told you I'm not ready to make a record.
You're not ready,
because
okay.
I don't know what's on all of them.
Okay, sorry. Then you were going to talk about something else.
Yes, Your Honor.
And now that we're finished with that, what can I do for you?
When Officer Kemple was on the stand, the court said that they wanted time to make a ruling. The ruling was in regards to whether or not the jury would hear that Officer Kemple has been no-billed by the grand jury. To recap on that, Your Honor, in pretrial hearings, the state told me that they did not intend to cross-examine any witnesses on internal affairs allegations, whether sustained or unsustained. I verified that they did not intend to do so. The topic first came up based upon my subpoenaing all these records when Mr. Lewis said, I don't intend to go into that. It was then visited again on the record where I said, I want to verify that you do not intend to cross-examine any of the witnesses on sustained allegations. And Mr. Lewis said no. And I said, not even my client. And he said, no, I don't intend to do that. He violated that agreement in front of the jury and violated any motions in limine and twice asked the witness about the sustained allegation, and in fact posted as, you were suspended 30 days for your unjustified use of deadly force. He opened the door on 2 separate times, violated an agreement he had put on record, and violated a motion in limine. And under those circumstances, the door has clearly been opened for the defense to go into this matter in front of the jury.
What matter do you want to get into?
I want to go into the
Precisely.
fact that he was cleared of criminal responsibility by the grand jury.
Okay. Mr. Lewis, any reply? Or Mr. Gladden?
Yes, my response is, I did agree not to get into any unsubstantiated IAD allegations. And when I spoke about that, I was speaking specifically with regard to the defendant. As pertains to Jason Kemple, obviously is not the defendant in this case. And I believe that the defense counsel opened the door to that when she put at issue his employment, which gave the impression to the jury that he was not punished whatsoever, and that his part of the shooting was justified as well. So that's why I went into that line of questioning to make clear to the jury that this was a sustained violation that he was punished for.
And Your Honor, to make the record very clear, I subpoenaed all of the officers' IA files, and a representative from DPD came down and said it was so voluminous. And at that point, Mr. Lewis said, I don't intend to get into any of that. We were talking about all of the officers, and based upon him talking about all of the officers, you asked, do we need all of these records anymore? And I said, you're not going to go into it with any of these officers. And he said, no, I'm not. Any of these officers. So that agreement was about any of the officers. And then we reiterated it on record, and it will be on record, that it was regarding any of the officers.
Okay. Yeah, he didn't get into that I mean, it was in response to your question about him still having employment there, and as I recall it, there was no objection when he asked it.
Judge, just so we're clear, I think that there was an objection as to the argumentativeness of that phrase when he asked that officer that question.
And it was sustained.
The argumentative, but he asked on read,
And then he asked again.
and there was no objection.
So the first time,
I mean, on the one hand, if there was a motion in limine, which I do recall, and you violated that, you should have approached before you got into that. There was no objection to that. So be that as it may, then the next question is you're saying that the misimpression in front of the jury now is that should be cleared up by me allowing you to get into the fact that Kimball was no-billed by the grand jury.
Correct, Your Honor. We're dealing
Okay.
with two different standards, the administrative and the criminal. And he used the wording of the criminal standard in his
By using which word?
unjustified use of deadly force. Self-defense is a justification, and deadly force is what we're dealing with.
Okay. All right. I'm not ready to make a ruling on that at this time. We're going to talk about the body cams. I have notes. I was researching all that yesterday. Just need to pull up my computer. But we need to talk about the body cams. Get this out of the way. It's 9:32. Mr. Lewis.
yes, sir.
And I'm not going to ask Ms. Madsen for any reply, but just how did we get these body cams into court today? Please narrate for the record where we stand.
Sure. So at the time this came up during trial yesterday, my investigator went over to Dallas Police Department immediately and met with Stephen Williams, who's the custodian of records for the body-worn camera program. At that time, we discovered that there were 10 videos that were not contained in the original investigative file by Detective Richardson. We obtained those videos, brought them back to the DA's office, uploaded them to TechShare, and made them discoverable to the defense. So at this point, they have them, and if you want me to state for the record, I can tell you what particular office they belong to, the amount of time that they are, and I can also answer the other questions that you had asked with regard to reports and things of that nature.
All right, go ahead.
Okay. So there's one from Officer Joel Tempt. His video is 10 minutes and 58 seconds long. Officer Eric Duffick, D-U-F-F-E-K. His video is 15 minutes and 2 seconds long. Officer Benjamin Yohner, Y-O-H-N-E-R, 9 minutes and 34 seconds. Officer Robert Wilcox, 2 minutes and 6 seconds. Officer Gary Birch, B-U-R-C-H, 15 minutes and 16 seconds. Officer Joel Theis, T-H-E-I-S, 45 minutes and 40 seconds. Officer Jenny Nance, 15 minutes and 4 seconds. There's another one for Officer Jenny Nance, which is 2 minutes and 52 seconds. Officer Roberto Garcia, 14 minutes and 36 seconds. And Officer Jason Sheets, S-C-H-E-T-Z, which is 17 minutes and 27 seconds. With regard to reports, the reports made by Officer Gary Birch, his report does not indicate whether or not he was wearing a body-worn camera that evening. There's a report by Officer Joel Theis. His report indicates that he was wearing a body-worn camera. There's a report by Officer Robert Wilcox, who testified yesterday, and his report indicates that he was wearing a body-worn camera. There's not a report by Officer Jenny Nance, but there's what's called
By Officer who?
I'm sorry, Jenny Nance. It's a field interview form, and she indicates on that form that she was wearing a body-worn camera. In the crime scene report, it lists all the officers who were present, but it does not give an indication as to whether or not they were wearing a body-worn camera. That includes Benjamin Yoder, Roberto Garcia, Jonathan Sheets, Eric Duffick, and Gary Birch.
Okay. And those reports that you're referring to, they've been turned over and you have received the reports, not the body cams, but the supplements, or do you know at this time? Okay. I'll give you time to look.
I'll get to the report. No objection.
Okay. All right. Excuse me. I'm going to give you, Ms. Madsen, all the time that you want to look at your reports, to look at what you've received. to look at those videos, and based on whatever you tell me to do next, I'll make a ruling, and we'll figure out how to go forward. While he was narrating that, I was pulling up my notes. Thank y'all for indulging the court, and I want to tell y'all where I'm at with this. And I feel like we're going to have a break, so y'all have an opportunity to research this issue. The problem that I really have with what you're saying is not necessarily that there's a conception that he didn't do anything wrong or that he did. My problem really is the language of a no bill, that a grand jury looked at this and they no billed it. And the reason why I have a problem with that is because of some cases that I read yesterday. Excuse me. And I'll give all the citations to y'all. Excuse me. And fundamentally, the purpose of a grand jury is that they hold a, they indict. A no bill does not mean that the crime was justified or lawful or in self-defense. I mean, that's straight out of Walker versus the state, which is 530 Southwest 2nd, 572. There's an opinion from 1932, Elam versus the state, which basically says that presenting the jury with a grand jury's opinion as to the merits of a disputed issue, whether the defendant was the aggressor and acted in self-defense in that case. So in other words, there was some guys who had been fighting and grand jury no-billed one. They wanted to put that in front of the jury, and it was held to be error because it's like an improper stamp of approval and sort of inviting the jury to speculate that the reason why the case was no-billed was because justification was in play, or that they acted in self-defense. And as a matter of law, that's not what a grand jury's purpose is, okay? So, I referred to him as a co-defendant. He may be a co-defendant as a matter of fact or as a matter of law, I'm not sure which. But it appears to me, though, that there's a body of law that says whatever happens on one co-defendant's trial or acquittal or in their criminal transaction is not relevant in another one's, unless they were to take the stand, and clearly that's not where we are today. So if it's not no bill, it seems to me that there may be another way to get at this, that he has not been subject to any criminal liability for this, something along those lines. Do you have any offers of that?
Yeah, Your Honor, that's why I phrased the question of you are not facing criminal responsibility.
Okay.
That is why I phrased it that way.
And-
I didn't intend to say that the grand jury cleared you or that you would know that. You
Well-
are not facing any criminal responsibility.
Okay, so let me ask it this way. And I don't know, at least off the top of my head, I know that we had a motion to suppress, I know he was charged with something, but to be very honest with you, I don't remember. What was he charged with?
I'm sorry, I think you're thinking of two different people.
Two different
Mr.
people.
Rosales had a motion to suppress.
Right.
Mr. Rosales is who you referred to as a co-defendant.
Right.
Are we speaking about Mr. Rosales or Officer Kimball at this time?
I'm referring to, okay. You're right. What I'm saying is, Kimball, was he charged and there was a no bill? Was he never charged? It was presented to the grand jury? Tell me about that.
It was presented to the grand jury at the same time as Officer Hess's was, I believe.
That's correct.
Okay.
He was no bill, Your Honor.
All right.
I believe the grand jury testimony was the same that we have in this case.
I mean, that very well may be, and I don't want to get into that, but the point of it is that if you're specifically staying away from what a grand jury has done, then I'm more amenable to listening to that. So the question is, you're going to ask him, if he was on the stand, what would he say? What would you ask him exactly?
In regards to your actions on January 18th, 2017, you were not currently facing any criminal responsibility.
Okay. So based on that question, are there any objections from Mr. Lewis or Mr. Gladden? Because I tend to agree with Ms. Madsen that there is an implication that he's been cleared. There's just the implication about, his involvement. Involvement's not the right word. Him being disciplined by the Dallas Police Department, okay? So what's your reply to that question that she's asking about? Or Mr. Gladden, either way.
Judge, first of all, we're talking about conduct of two different individuals. Officer Kemple testified that he fired a shot and that he believed that that shot was justified based on his perception of the circumstances. Mr. Lewis pointed out that he faced discipline by the Dallas Police Department for violating their use of force policy for firing his shot. The justification for Officer Kemple firing his shot has nothing to do with any justification for Officer Hess firing his shot, because under criminal law, justification is based on the belief of the actor.
I agree with that.
And Officer Kemple is not relying on Officer Hess's belief about anything for his conduct. His conduct is based on his testimony as to what he believed.
I agree with that.
And then second of all, so that is the first relevance aspect to any criminal liability for Officer Kemple.
And I agree with that. And it seems to me, though, that we've crossed over now to what doors have been opened by the testimony. And surely, at the beginning of the trial, his lack of criminal responsibility, or whatever y'all want to call it, was not relevant. But that's not where we find ourselves now on the state of this record. So the question is, does that open the door or not? And that's really what we're wrestling with, what I'm wrestling with.
And I think Ms. Madsen's sole argument for saying that it opens the door is that Mr. Lewis used language of unjustified use of deadly force. Can I ask Mr. Lewis one question?
Sure.
So what Mr. Lewis has told me is that what Officer Kemple was sustained for was violation of deadly force policy. So I think the question for this court is, can that be fairly characterized as unjustified use of deadly force in light of the fact that the language of the deadly force policy is in evidence for this jury to consider? Is there a risk of the jury confusing the administrative discipline against Officer Kemple based on the general orders that they have with criminal liability for Officer Hess based on the legal standards that the court is going to give to the jury? Only if it can be argued that they would be confusing those, even though they have all of the resources to keep them separate, would the door even arguably be open at that point? And then the second issue is the basis for saying that he's not facing criminal liability is the grand jury no bill. Now, as you pointed out, grand jury no bill simply means that the grand jury on that date didn't vote to indict. It's not a endorsement of justification. It's not an endorsement of guilt or innocence, just in the same way that an indictment can't be used against the defendant. How can we argue that the lack of an indictment can be used a lack of indictment of someone else can be used for the defendant? It's not related to the issue of criminal culpability in this case at all.
I agree with that. Okay.
May I respond?
Sure.
I would agree that it's not related, but it was cast in a light that it was related. And I disagree with Mr. Glavin that my only grounds, because you see, I objected to that question, and Mr. Lewis restated it, and then he brought it up again. So there's 3 different times that he is phrasing the question, 3 different ways. And he didn't say in administrative. In fact, he said you were punished. Okay? And then cast it in, you were punished for doing something wrong. He conflated the issues. He confused the issues and created this misperception. And he did so 3 separate times. That is what got us here, is his characterization and linking them together.
During my question of Officer Kemple, there was no objection the first time I asked it. There was an objection the second time. And I don't believe that I conflated the two. I specifically said that you were punished by the Dallas Police Department for violating their use of force policy. I in no way stated that that was criminal or applied to it. It's not criminal. I simply said that you were punished by the Dallas Police Department for violations of general
Okay. All right. I'm going to let you ask the question, and I'll entertain a limiting instruction that y'all want to give if you want to. I'll overrule the state's objection. You can ask that very specific question that you asked in your proffer, and nothing more. So that ought to put that issue to bed. Now, you just won.
Huh?
You just won.
Oh,
No. This is a
Okay.
separate issue, Judge.
You say, you're ahead. Go ahead.
Want me to sit down while we're ahead?
No.
Judge, on the 3rd day of this month, you issued an order regarding the state's motion to eliminate. And we would like you to revisit that as regards Mr. Rosales' status as being on felony probation. We would also like to get into the fact that Ms. Dawes and Mr. Rosales have been arrested on numerous occasions. We do not intend to use this as character evidence. We think that under 401 and 402, it's relevant, it's material, it goes to a fact that issue, it actually goes to the heart of our defense, because it goes to their intent, motive, motivation, and absence of mistake. We believe that the state has opened the door to these questions on several occasions by the choice of the wording, the questions they asked Mr. Samples, Officer Lickbar, and Officer Evans.
What's the words that you're talking about?
Mr. Lewis has intentionally and repeatedly endeavored to leave a false impression with the jury that we don't know why or what motivated them. Ms. Madsen read a bunch of these questions into the record yesterday, if you recall.
I do recall that.
Look, George has time and time again left an impression with the jury that perhaps Mr. Rosales and Ms. Dawes were just startled. They were sleeping. They were woken up by strange people with strange lights, and they didn't know they were police officers. That's the impression that he has left with the jury. He has stated over and over again, we don't know, or you didn't know them. We don't know why they were doing what they were doing.
Well, okay.
And there is a reasonable inference that the jury can draw from the fact that they had had encounters with the police on several occasions. They knew the drill and they knew what was happening.
Okay. I don't disagree that jurors might think that, but what I'm saying is that I find it more likely that they would suspect that based on improper character evidence that is not admissible in my opinion. That's the basis for my ruling. It hasn't changed, and I haven't heard a question to change my mind on that.
I think I have one thing on that, Judge. With respect
On
to-
what he just said?
I'm sorry.
What he just said? You just won too.
And
Y'all need to
Judge,
quit while you're ahead.
Just to be clear, under 404B2, we're not using this character evidence. And I think that you can cure any concerns the court has about character evidence and conformity therewith with a limiting instruction.
I understand that. What I've tried really, really hard to do for this trial is to confine what this jury's consideration is to be based on what happened and what was happening that night. And to me, what you're talking about is too far afield from what was happening in the minds of those that were involved. So that's my ruling. It hasn't changed. It's not going to change unless, other evidence comes up, and I'll hear requests at that time. Yes, ma'am.
At this time, we would request that we be allowed to admit the immunity order in front of the jury and to let the jury know that Mr. Rosales is not available to us to call for as a witness.
That request is denied.
We would re-urge the fact that the state has created a false impression with the jury intentionally, talking about in their opening argument that there was no way to know what was going on in that car, when we know that they had interviewed Mr. Rosales and given him immunity and sponsored his testimony with the grand jury when they believed that it would benefit them. But when they later investigated and found out that he had lied to the grand jury, and that's going to be contained in the Brady notices by Brown and Minyard and Carl Skaggs, that he had lied to the grand jury. They have now insulated it so that, one, we can't call him and impeach him, and two, they can continue to speculate and pretend that he didn't lie to the police that night, that he didn't lie to them, that this whole case doesn't have an answer to the very question that was the state's opening. Why would the police do this?
All right,
What were the people doing in the car?
I've heard that argument now. I am rejecting that argument as a theory of admissibility. I'm not letting that in. That hasn't changed. I haven't heard anything that's going to change my mind about that either. The evidence is inadmissible. I don't agree by my silence. The record should not reflect that I agree with anybody who says that Mr. Lewis is intentionally doing this in some kind of a disparaging way. Those are strategic decisions that I'm not going to speculate about. So my silence on that is not an endorsement of that strategy either way.
And Your Honor, when those strategic decisions create a false impression with the jury, then Rule 103 allows you to make rulings that will clear up any of those false impressions. We would ask that you would admit any of these items so that the jury could hear the truth.
I've heard that request now more than once. I've heard it repeatedly, even though the record before me hasn't changed. And once again, your request is respectfully and now finally and unequivocally denied. Is there anything else about that issue that anybody wants to talk about? Okay.
Judge, again, I'm going to make a request that this jury's been back here since whenever you told them to get back here at 8:30. And invariably, it's been my experience over 45 years, that once they come back and there's a delay, it always gets held against the defendant, especially if it's a presentation of the defendant's case in this case, that they be told specifically that we are not responsible for the delay in this particular case. It's the failure to comply with previous court rulings with regards to turning over discovery once again that brings us to this point, so that they are not left to speculate or insinuate or imply that this is somehow some delaying tactic on the part of defense lawyers as opposed to what the reality is in this particular case.
All right. I'll take the matter under advisement. I'll think about what to say. What do you intend to do now, Ms. Mattson?
All witnesses, Your Honor, we'll just need a brief
Okay. We will,
No, we're ready to go.
all right, let's take, we're going to start at precisely 10 o'clock. That's 8 minutes from now. Round up your witness. Ms. Wood, take a break. Sheriff, round up the jurors. Yes. And actually, I'm sorry, lawyers, y'all need to stay right there.
And Judge, so
Hold on, please. There's another issue that's come up. I need to see the lawyers. Court's in recess. Y'all can be seated. We're off the record, but I need to see the lawyers. So a juror went to her car yesterday, and